Salutations, respected viewers. This is George from Ireland. In this video I shall be continuing my introduction to English law. It's often called common law because, well, I won't say why it's called common law, but it applies not just to England, but the overarching principles apply to many Commonwealth countries. That's not to say the individual statutes are all the same. Alright, so this is about the nuts and bolts of common law. One of the main things to notice is that the legal system is divided into two branches, the judicial system I should say, the system of judges and courts, two divisions. There's the criminal division and the civil division. So the civil division is anything that is not criminal. And we might talk about civil law in that sense, to mean everything that's not criminal. And obviously that's subdivided into many different areas. So the criminal division, the lowest court, is the magistrate's court, and that deals with minor crimes, and the magistrate can award a sentence of up to 2 years. And if a case comes before the magistrate where he feels that his sentencing powers are inadequate because the offence was too grievous, he may refer it up to the Crown Court, which is the next level above. And fairly serious crimes, will be murder, rape, so on, they start in the Crown Court because the sentencing powers are anything up to life imprisonment. So magistrates, they can be stipendiary magistrates, as in they're paid a salary. They've been a solicitor or barrister themselves, and after a successful career they've got into that. Or the magistrates can be lay magistrates, you or me. Ordinary adults should be respectable members of the community. I don't think they have to have a degree, but they usually do. And they don't have a specific legal education. And they sit in panels of 3. And they do it unpaid. They do it out of a sense of public duty. These lay magistrates dealing with low-level crime. Now, in the criminal division, we've had magistrates' court, up to Crown Court, up to Court of Appeal. If you're found guilty of a crime, you have a right to appeal. Once on the facts, that the facts were wrong, they were misrepresented. That's not your fingerprint, that's not your DNA. The eyewitness did not identify you, or something like that. If you felt that appeals fails, you can appeal again on the law, that the judge erred in law, that there was some sort of misinterpretation, things like that. I have heard of cases where there are 3 appeals, but I'm not quite sure why. Now, the case can actually go up beyond the Court of Appeal to the Supreme Court. That's highly unusual. Very occasionally they go to the European Court of Human Rights in Strasbourg. The European Court of Human Rights is adjudicating cases where they touch on the European Convention on Human Rights, and when all domestic remedies have been tried and run out. So again, it's highly unusual for cases to go that far. And remember, the European Court of Human Rights is not to do with the European Union. Now look at the civil division. So the civil division has the county court. That's the lowest court in the civil division for minor issues. Even below that, there's a small claims court. If you're reasonably intelligent adult, you can represent yourself, and it's in claims of a few £100s, even a few £1,000 about you weren't paid for whatever it was, goods or services. And usually no lawyers involved in that. But anyway, most civil claims would start in the county court. Divorce, for instance. Minor contract issues, and then they go up to the High Court. Some things start in the High Court if it's a serious amount of money or a really important dispute, and after the High Court then things can be appealed. If you lose, it can go up to the Court of Appeal. Notice that the Court of Appeal is joined together. The criminal division and civil division meet in the Court of Appeal, and above the Court of Appeal is the Supreme Court, and just very occasionally these things get sent to the European Court of Human Rights again. Bear in mind, the Supreme Court of the United Kingdom was quite a new thing, only about 10 years old. Okay, so these courts are said to go up in tiers, as in level, not tiers as in weeping and sobbing, but T-I-E-R, as in tierce, like a third in French, except there are 4 of them. Well, 5 if you include the European Court of Human Rights. So look at case names. Now, cases have a short name. The real name may be as long as your arm, but take the case. If you read Massingbird v. Simmons, 2002, you do not pronounce it V. You'd say Massingbird and Simmons, 2002. I know it's confusing. or you don't say Massingbird versus Simmons 2002. In Commonwealth countries, it's and, or indeed you can say against. In the United States, they often say V, and the V stands for versus, the Latin word for against. But in this usual quirky English way, the V is not pronounced V, or even the Latin word represents versus. You either say and or else against. So the first named party is the party that moved the action. In this case, Massingbird and Simmons. Massingbird moved the action, as in he's suing Simmons. In criminal cases, it's the Crown and Snodgrass, okay, or the Crown against Snodgrass. You can say it that way. Criminal cases, so sometimes put R standing for Regina, the Queen. On the days of a king, it might be Rex, the King. So R and Snodgrass, or R against Snodgrass. Don't say R v Snodgrass or R versus Snodgrass. I teach people this rule, but even I slip up and say it wrong sometimes. So party is a person or an organisation. It doesn't mean it's a political party or indeed a soiree. We say a party because a party could be one person, could be many people, could be several organisations together. So the second named party, Massingbird and Simmons, is the one defending the action. So the claimant is the first named party, and the defendant is the second named party. Of course, in criminal, it's the Crown, or R, against whoever the defendant is. The year of decision is given in square brackets afterwards. Note, this is the year that the case was decided, which is not necessarily the same as the year the case started. The case may have started earlier. Take Forzi and Zia, 1990. If the case began in 1989 but was decided in 1990, then the year of decision is given, 1990, not 1989 when it started. Okay, so to recap, remember, if it's Thistlewood v. Michaels, you read it as Thistlewood and Michaels. It gets a bit confusing if there's several claimants, or indeed several defendants. Sometimes more than one party moves an action. Moreover, more than one party could defend an action. It could be Vincent, Simmons and Huck against Peters, Borough and Fairclough. So you'd have to say against in the middle, because the and would be very confusing. Otherwise, it'd be Vincent, Simmons and Hack and Peters, Borough and Fairclough. Think, what? Who's against whom? So that's the way we do it. Okay. So remember, V should be read aloud as the word and, or if that would be confusing, just say against. Okay. So if in the fictitious case of Clyde, and you see Clyde v. Benson, you read it as Clyde against Benson, or Clyde and Benson, whichever you prefer. In that case, it's not confusing. There are several parties to an action. You don't need to list them all. I'll come up with another fictive case. Supposing you had Farron, House, Porterfield, and ICI, but you say against, BBC, White House, Grass, and Terrington. Rather than list them all, Farron, House, Porterfield, and ICI. No. You could just say Farron and others against BBC and others, rather than listing all the defendants. BBC, White House, Grass, and Terrington. So the name of the case is usually written in italics. A case may be heard again and again, so it might be called number 1, number 2, number 3, and so forth. A well-known example is Bow Street Court Stipendiary Magistrate and Pinochet Ugarte number 2, because there's already been such a case but number 1. Stipendiary Magistrate, which I just mentioned, as in he or she is a salaried junior judge dealing with low-level criminal cases. Someone's arrested, and even to be charged with murder, the initial hearing, the bail hearing, will be in a magistrate's court. Say, police, do you oppose bail? Yes, we do, because he's a flight risk. Or yes, we do, because she's a bad character, she's got a few convictions. And if the police oppose bail, then usually the judge goes with that, remands the person in custody, doesn't let them out. Even though the trial will actually be in the Crown Court, the bail appearance is usually in the magistrate's court. So people often put the year decision to help them understand the historicity of the event, but also it could be confusing if there were 2 or more cases with the same name, and therefore the year decision would be needed to help contradistinction between the 2 cases with a like name. So if we had Crown and Samuel, that would be an example. Crown can be written as R, remember, as in Regina or Rex. Crown and Bing, or Crown against Bing, both are acceptable. If it says R, you could say it out loud as the Crown. It's not the Queen who personally prosecutes people, but a title is a constitutional abstraction, and things are done in her name. The Royal Coat of Arms is up in the courtrooms in England, Wales, and Scotland, for that matter, but not in Northern Ireland. Due to the Good Friday Agreement, nationalists didn't like that. So in other countries, it's the country's name is used in criminal cases, because it's though the country is prosecuting, like if there was a case like India and Massoud, or there were civil cases like in the Republic of Ireland, Norris and Ireland, because David Norris took out an action against the Republic of Ireland to try and strike down this Offences Against the Person Act 1861, which criminalised homosexuality. He claimed it was repugnant to the Irish Constitution. So we're back in 1976. He lost his case. Personal names are occasionally given because the surname is too confusing, the surname. So there might be R. Ann Smith already, so then there's another R. Ann Smith, so I have to say R. Ann Smith brackets Frederick to distinguish it. So there are lots of law reports to read, the Western law reports, which are for Western England, and there are law reports which specialise in particular areas of law, because, you know, a case can take months, years. The transcripts could run to millions of words, but we don't need to know everything. We just need to know the crucial points. Nobody could possibly memorise or absorb all that. The Court of Appeal only deals with reports at that level, because they're Court of Appeal court reports. A report will summarise the salient facts and any developments. What's new out of this case? Sometimes it really is a seminal moment, otherwise it's direction of travel. Millions of cases go on every year. They cannot all be reported, not possibly. Most of them don't change the law, so they're not reported. Court reporters do not go and read up on all cases. Many cases are open and shut. If a case is very straightforward and there's no innovation, then there is nothing to report. It's just as expected. A gigantic case involving millions of words of oral submission and indeed written documents is far more than anyone can possibly process. A report therefore has to be a summary of the key points. And what was decided and why? What is significant about that? Look at the rationes, possibly obiter dicta. There's superb sources such as LexisNexis, as in network of the law in Latin, which you could look up. You have to pay to subscribe to that one. So, out of court. We perhaps overemphasize what goes on in court. So I'll do another video later on settling things out of court.